the law is settled. That any homicide, my Lord, is presumed to be caused unlawfully unless it was accidental or authorized by law. In this case, my Lord, there is nothing that was laid to rebut that legal presumption. Nothing pointed to the homicide in issue being either accidental or justifiable or lawfully caused. Although the defense were not clear in their submissions on this particular ingredient, my Lord, we did not hear any contestation from them to the effect that this death was not caused through an unlawful means. So we submit that that ingredient is also properly established. My Lord, the third ingredient.
Let's interpret ingredient by ingredient.
Okay.
Ensonga endala erina okukakasibwa oludda olwabi y'ey'okuba nti okufa kwaleetebwa oba kwakolebwa mu ekikolwa ekyo kyakolebwa mu bumenyi bw'amateeka. Mwaba gavumenti agamba nti etteeka lyakakasibwa nti buli okufa kuba kumenya mateeka okuggyako nga waliwo ekikakasizza nti tekumenya mateeka. Oludda oluwawaabirwa teruleeseeyo oba terulazeeyo nsonga yonna eraga nti okufa kuno tekwamenya mateeka oba nga kwali kwagwawo mu butanwa oba nga kwaliwo mu mateeka era nga oludda olwabi teruleeseeyo kulaga nti okufa kw'abaana abafa kwali mu mateeka.
My Lord, on the third ingredient that the death was caused with malice aforethought, my Lord, reference is made to the provision of section 174 of the Penal Code Act, which defines malice aforethought as either an intention to cause death of a person or the knowledge that an act causing death will probably cause the death of some person. Now the question that your Lordship has to answer is whether whoever assaulted the deceased children in the manner described through the evidence of PW 1 and other eyewitnesses intended to cause death or knew that such assault would probably cause death. My Lord, malice aforethought can be inferred because it is a mental element. It can be inferred from the circumstances, and we have provided authorities, my Lord, to highlight some of the circumstances from which court can make an inference. My Lord, these include the type of weapon used, and my Lord, in this case, the weapon is a knife, which is a deadly weapon. The second circumstance, my Lord, is the nature of injuries inflicted, and in our case, we have deep cut wounds to the neck. The other consideration is the part of the body affected. We submit, my Lord, that in this case, that part of the body was the neck, which is a vulnerable part of a human being. And the fourth consideration to consider, my Lord, is the conduct of the accused person, either before, during, or even after the attack. My Lord, we have led through the various witnesses incontrovertible evidence. Speaking to the prior planning of the accused and his meticulous execution of his plan. Part of that evidence, my Lord, is the testimony of PW6, to whom the accused disclosed that he scouted the scene of crime a day before, we also, my Lord, have evidence of PW 8, from whom the accused hired a motor vehicle to ease his scouting movement on the 1st of April this year. We have also highlighted evidence, my Lord, to the effect that in the process of executing the victims, the accused scared of PW6, who was attempting to rescue the children. But my Lord, the same witness also gave evidence to the effect that after killing the children, the accused threw away the knife. An act that we submit was intended at concealing evidence, knowing the fatal consequences. So, my Lord, the participation of the accused person
ensonga endala yekigendererwa nga kino enennyonnyola akawaayiro ak'Ekikumi-74 ak'etteeka ery'ebibonerezo nga wano kino oludda oluwaabi lwaleeta abajulizi okukakasa abaaliwo okulaba ebikolwa bino nga bigenda mu maaso, ng'era kuno kwe kuli mu kunnyonnyola, kuno kwe kuli
akawaayiro akalala ka kigendererwa omuntu ng'akoze omusango bwe guti, balina okulaba nti oba omuntu oyo yali amanyi oba ekigendererwa kye yalina okukola omusango bwe gutyo, n'agamba nti omuntu yenna eyafumita abaana abo mu ngeri gye yabafumitamu yali amanyi, yali alina ekigendererwa. Omujulizi eyasooka n'abalala baaliwo bagamba nti yakigenderera okukola ekyo kye yakola ate ne kiviirako abaana okufa. N'agamba nti ekigendererwa bakirabira ku bintu bingi kubanga kibeera mu mutwe gw'omuntu, ate ebintu ebyo basobola kulaba ku kisi ekyakozesebwa ng'akambe kubanga akabulabe, basobola kulabira ku biwundu oba obuvune obutuusizaako omuntu nga mu musango guno abaana bano baabasala mu bulago, era balina okulaba ekitundu ki omuntu kyatuusizaako obuvune, era mu musango guno omuntu ono yafumita obulago, ate obulago kitundu kya nkizo nnyo ku mubiri gw'omuntu, era balabira n'engeri omuntu gye yeeyisizaamu mu kukola omusango ogwo ng'amaze okugukola.
So, my Lord, we submit that with that evidence establishes the ingredient of malice aforethought. The fourth and final ingredient of participation, we laid both direct and circumstantial evidence to not just place the accused at the scene of crime, but, my Lord, to prove that he directly participated in causing of the death of the 4 infants. Again, my Lord, we highlight the testimonies of the 2 eyewitnesses, PW 6 and 7, My Lord, we also highlight the fact that the accused was arrested at the scene. My Lord, we also laid evidence of PW 17 whose findings were that the accused's trousers in prosecution exhibit 16 bore the blood of one of the victims. In addition, my Lord, on the recovered murder weapon, the knife, evidence found the DNA of the accused on the knife handle, which was exhibit 4, among the examined items. My Lord, what this means is that it directly connects the accused to be the user of that knife that killed the infant. My Lord, there was also evidence from the sunglasses of the accused of the DNA of body 39, which belonged to one of the deceased children, Keisha Agenroth. My Lord, on the accused's trousers, it was DNA of body 37 of Ignatius Seruyange.
What was on the trousers?
DNA of body 37, which body, my Lord, belonged to Ignatius Seruyange. My Lord, that evidence and more that we laid on record is sufficient to place the accused at the scene, but also prove his direct participation. We want to add, my Lord, that throughout his defense, the accused never denied causing the death. Of the deceased children. He only claimed that he believed he did not have the intention to cause their death. He claimed that he was distressed between January and March this year, and that his killing of the 4 children on April the 2nd could have had something to do with his alleged distress. My Lord, from the accused's defense, we understand him to be raising a defense of insanity, for which we want to address court.
nti ku kyokulaga oba omuwaabirwa yeeyaza omusango guno oba nedda baleeta obujulizi obw'enjawulo. Obujulizi buno bumusanga we batira abaana ate ne baleeta obujulizi bulaga nti ye yabatta. Baleeta obujulizi bw'abantu ababiri abaaliwo, ye omujulizi ow'omukaaga n'ow'omusanvu, era bagamba nti omwami Okello bamukwatira mu kifo abaana abo we baafiira. Baleeta obujulizi bw'omujulizi wa 17 era yajja n'agamba nti empale Okello gye yali ayambadde gye baleeta ng'ekizibito ekyo16 yaliko omusaayi gw'omu ku baana baafa, era omwana oyo omulambo baali baguwadde ennamba 37 ate nga gwali mulambo gwa Seruyange. Era ne baleeta obujulizi obulala nga bagamba nti akambe akakozesebwa kaliko endagabutonde ya mwami Okello, nti ekyo kitaga nti mwami Okello ye yakozesa akambe ako. Obujulizi obulala buva ku galubindi ezaali za mwami Okello, baazikebera ne basanga nga zaaliko omusaayi gw'omulambo gwe baali bawadde namba 39 nga gwali gwa Keisha. Nti obujulizi obwo n'obulala bumala okulaga nti omwami Okello yali mu kifo ekyo era yaza omusango guno. Nti yali nga yeewozaako ye teyeegaana musango, wabula kye yeegaana kyokka yali agamba nti ye kino teyakigenderera okuvaako okufa kw'abaana abo. N'agamba nti wakati wa mwezi gwa January ne March omwaka guno yali alina obuzibu, yali mwenyamivu, nti ate agamba nti kyandibanga kye kyamuviirako okutta abaana abo ng'ennaku z'omwezi 2 ogwokuna omwaka guno. Nti mu defensi ye alabika nga agamba nti yali omutwe gwe tegukola bulungi, era kati omuwabi wa gavumenti kyagenda kwogerako.